Yeah, of course.
Speak louder.
Sorry?
Do you want to get that off?
One second, I'll just slide it across.
You. She was asking for the tape so you can get through there.
All right.
The court apologises for the inconvenience caused by that break in transmission. Yes. Mr. Hooper.
My lord, I was making it was never pleaded nor put that there had been a fraud going on, and in fact it had been made expressly clear in opening submissions by Mr. Cousins at trial that he wasn't going to be alleging that sort of case, and he wasn't going to be...
Well, you want to make clear on your client's behalf, and I understand why you want to do it, that that sort of allegation is not a live one in these proceedings. It wasn't an allegation that was made, and it's not one that arises on this appeal by virtue of the litigation history.
Correct, my lord.
All right. Is there anything more you need to say about that?
No, my lord.
Right. Thank you.
In which case, my lords, I will turn to the substance of the contract itself.
Yes.
And I'd like to start with the application of the Sale of Goods Act. I start here, my lord, because this is genuinely a new point. I don't blame anybody for that, but it is to some degree a symptom perhaps of so many people looking at this case on Mr. Carl's side and with fresh eyes. But it was common ground on the pleadings that the Sale of Goods Act applied. It wasn't a point that was raised...
Applied to the gearbox.
Applied to the gearbox component of the contract.
Yeah.
Correct, my lady. It wasn't raised in closing submissions at trial, nor in fact in oral opening submissions at trial. The reason for that is because I objected to it in my oral opening on the first day of the trial on the basis of it being common ground on the pleadings that the Sale of Goods Act applied. And it's true that the judge finds that the Sale of Goods Act applied in the judgment. In my submission, he didn't need to find that because it was common ground. And if for whatever reason he had not found that, then we would have probably have applied for permission to appeal on the basis that it wasn't open to him to make that finding.
Whether it applies or not is a matter for the judge, not a matter for the parties to agree about. But the fact that the parties did agree about it and the judge also so found is the history of the litigation as you describe it.
Yes, my lord.
Can you just give us the reference to where it is common ground on the pleadings?
I can, indeed, my lord. In fact, it was actually Mr. Carl who first pleaded the Act. It's in his defence. If we turn to the core bundle, tab B6, B91. And it's paragraph 19. 19 sub 1, the point is made that the agreement didn't require Mr. Carl to ship the gearbox to Fisken's at Fisken's cost, and it says delivery was to take place at the address of Canepa. 19A is an interpretation point in respect of the agreement, and 19B says that the position is governed by, then in brackets, or analogous with, so therefore alternative, with section 29(2) of the Sale of Goods Act. Then we have my response to rather a full Part 18 request, which is in the supplemental bundle at tab F16, F125. Beginning at paragraph 18. And I plead a case on construction at 18.1, and then at 18.2 and .3 plead a case by reference to the 1979 Act.
Sorry, which page are you reading from?
Page F126, my lady. F126. In tab F16.
Yeah, thank you.
And then at paragraph 21.5 of the RFI response on F127, we respond specifically to paragraph 19(1)(b) of the defence and counterclaim, which was the plea I just took you to, and plead a case on the 1979 Act. And then we come to the amended reply to the claimant's amended defence to counterclaim. So this was Mr. Carl's next pleading, and that's at tab F17 and at page F133, paragraph 7. Mr. Carl pleads in response to, among other things, those two paragraphs in my RFI response. He makes the point that he makes a point by reference to the interpretation of the Sale of Goods Act as to what a reasonable opportunity to examine would comprise, but makes no suggestion that the Sale of Goods Act does not apply. The first time we get wind of the notion that the Sale of Goods Act would not apply to the gearbox component of the agreement is in Mr. Cousin's skeleton argument, which is at F18 in the supplemental bundle, at F136, paragraph 65, sub 1. And that paragraph is, by and large, what is quoted in the judgment at the paragraph that my learned friends took you to earlier. But it's not actually a point that was available on the pleadings, which is why when we come to the oral opening submissions, which are at D1 of the bundle, page D1. Internal pages 23 to 24, I object to Mr. Cousins running this case. And that was the last that was said about it. Incidentally, the notion of the Sale of Goods Act applying to the gearbox component of the contract formed no part of the draft grounds of appeal that were before the judge, presumably because it was understood that it wasn't open to run.
Thank you.
If my lords are willing to consider the point, I've set out plainly in my skeleton argument why this was a contract to which the Sale of Goods Act clearly applied. But just turning to section 2 of the Act itself, which is at tab 1 of the authorities bundle. Section 2, tab 1. Sorry, section 2, subsection 1. There's no issue that property was going to transfer in the gearbox. There's a dispute about at what stage property was to pass, but there's obviously no dispute that property was to pass in the gearbox. So the question then on the terms of the Act is simply whether there was going to be cash consideration, i.e. a price, for the gearbox. And that is therefore bound up inexorably with issue 8, which is, was consideration paid for the gearbox? which does not form part of the grounds of appeal and is outside my Lord Justice Mayall's order granting permission to appeal. Arguably, in any case, the question of whether consideration is paid is sometimes considered to be a matter of fact in any event. But I'll go on to look at it should my lords be willing to consider the point.
Well, if you're right that the intention was to transfer property in the gearbox, then that must have been for a price, unless it was a gift.
Exactly, my lord, which appears to be Mr. Carr's case. As I understand it, Mr. Carr's case is that he gifted the gearbox to GFL. Yep. In certain circumstances, he might get a fee for services rendered, but his case must be the gearbox was a gift.
Yep.
And that, of course, my lord, takes this outside, or it's markedly different from the OW bunkers scenario, where property wasn't going to be transferred in the bunkers that were used. Here, there was always an intention to transfer property. So those are my sort of threshold submissions, if you like, my lords. But I can engage with this as a matter. I'm going to engage with this as a matter of substance as well. If we turn to the contract itself, which is at the back of the core bundle, clause 7.3 says that the purchase price reflects adjustments for diminution in value caused by the inability to deliver the gearbox with the GTO. I believe this was my Lord Justice Jackson's point, that you can have a scenario where property was to pass and there was to be a sale. It's just delivery isn't to take place at the same time as another component of the sale contract. This actually accords with the manner in which the price was negotiated. Originally, it was proposed that there was going to be a $44.5 million deal. And that was, if you like, a gearbox sale. So that was the GTO with the original gearbox. It was then proposed that there be a retention of $1 million. And that was, I think it was proposed by GFL that might be held in escrow pending the gearbox turning up. So essentially you get a no gearbox sale of $43.5 million. What ends up happening is the parties meet in the middle on a $44 million sale, and both sides assume a risk there. So GFL pays $500,000 more than it wanted to in a no gearbox sale, but assumes the risk that the gearbox might never turn up. And Mr. Carl gets $500,000 less than he would have done in a gearbox sale, but at the same time the gearbox may never turn up. So clause 7.3 actually echoes the way the price structure worked, and demonstrates in my submission that it was always the intention that the price, the $44 million, was to include the gearbox and be part of the initial transaction. Otherwise, as Lord Justice Mayall's notes, you end up in a bizarre situation, and this was in fact what the judge recognised in his consideration on issue 8, which was the consideration issue. You end up in a really bizarre situation where you've just got a gift of a gearbox as part of this contract, which seems somewhat contrary to what the parties would have intended.
Well, you have in a way anyway, because if the gearbox does turn up, then you've got a car with two gearboxes.
I suppose that's right, my lord, but in a sense, what you're paying for is the original gearbox. That's what the extra component's for. That's why you end up at $44 million, because you're buying the original N2, which all the parties agreed needed to be put back together with the GTA.
Yes. Well, had it been a situation where Mr. Carl had simply said, Mr. Canepa, when can we come and pick it up? And Mr. Canepa had said Wednesday. Then that's where we'd have ended up. 44 million and the gearbox thrown in, but you've got your problem is with 7-Eleven.
Yes, but that goes, my lord, to the question of whether Mr. Carr was entitled to a fee for his services. I'm not suggesting that the fee was a component of the price. I accept that the fee was a component, was a fee for services that arose in certain particular situations.
Yes, it was an incentive to Mr. Carl not to leave the gearbox mouldering when it could be recovered and reunited.
Yes, but as distinct from the price. And also on the point of incentive, I'll come on to this, but that actually makes a lot more sense in circumstances where the gearbox might turn up from a third party other than Canepa, because even though they didn't know, Mr. Carr at least thought the gearbox was with Canepa at the time. So if he's right about that, he's not really getting he'd be getting $500,000 for doing not much. Whereas if it turned up with somebody else on the other side of the world, that starts to look like something which one would expect would be more fully compensated.
But we have to remember that although it was strongly suspected that the gearbox may have been with Mr. Canepa, and in fact it turned out that Mr. Canepa was able to produce it, there were risks involved in the alternative scenario, which is that Mr. Canepa couldn't find it, didn't produce it, and nobody could find it.
Exactly, my lord, which is why the price structure was as it was. Both parties take a risk there. GFL pays $500,000 more than it.
Right. Well, I understand that, but at the moment I'm not seeing how this is advancing your case in relation to what the central issue is here, which is whether a fee was payable.
It's not, my lord. This relates purely to the question of whether there was money consideration for the gearbox, i.e. whether the Sale of Goods Act applies to the gearbox component of the contract.
Right, so it all goes to where it has to be delivered, does it?
Yes, it will go to...
Is this a long run up to that it should be delivered in one place rather than another?
Yes, to a degree, my lord, but it's obviously said against me that the Sale of Goods Act doesn't apply to this contract. My submission is that there is cash consideration for the gearbox.
But my lord's asking you why it matters.
Because it goes, thank you, I'm grateful, my lady. It goes to this question of what implied terms you get from the statute. And so you have, under the statute, Section 34, which provides the right to examine, and you have Section 29, which goes to the place of delivery. Now, the reason why those two statutorily implied terms are important is because what was said and what Mr. Carr pleaded was that there was a repudiatory breach of contract because Fisken was demanding to inspect the gearbox and was also demanding delivery at its address in London. And in order for that to be a repudiatory breach of contract, obviously those can't be terms of the contract, they've got to be contrary to it. But if they're implied by statute, then that can't be a repudiatory breach. The reason why that's then important was because if Mr. Carl terminated the contract, then there can't be specific performance of it. One further point before moving on to inspection, my lord, I would just like to look at clause 7.4. Apologies, I wanted to look at clause 7, yes indeed, clause 7.4, which notes that in consideration of the buyer accepting the GTO without the gearbox, the seller agrees to use best efforts. What that suggests is that absent that consideration, i.e. seller agreeing to use best efforts, or rather that the buyer would ordinarily be able to reject the GTO without the original gearbox, which does suggest that it's bought the gearbox, because otherwise it could reject it. Which does again just support my position that the gearbox was to be included in the price and as part of the transaction. coming to inspection, there are two components to this. There's the right to inspect, and then there's the place of inspection. So, as to the right to inspect, putting the Sale of Goods Act to one side, the suggestion that there's no right to inspect a gearbox which is specifically numbered in the contract is an original component of a car that is subject to a $44 million odd transaction. It is a little difficult to understand why the parties could possibly have conceived that there would be no right to inspect the gearbox at all. There was real merit in putting the GTO back together, so obviously the GTO was going to be inspected, and there's merit therefore in making sure that what you're putting back with it is part of the original component. That's also entirely consistent with the way in which the contract works, because the gearbox is a defined term. It's the gearbox that's numbered N2, clause 7.1, originally delivered with the GTO. It's got a capital letter. Then everything in clause 7 presumes that the gearbox is the gearbox. And so there can't be an obligation to accept something, let alone pay a fee in respect of its recovery and return, unless the gearbox is the gearbox, which requires inspection. And that, in my submission, is entirely consistent with the provisions of the contract and the parties' intentions. But it's also consistent with Section 34 of the Sale of Goods Act, which says that you're not obliged to accept goods until you've been afforded a reasonable right of inspection. So really, my submission on the right to inspect is that simple. The difficulty perhaps arises where one asks, where should inspection take place? But here, the judgment records what is effectively common ground. That it's at paragraph 148 of the judgment. And it's just noted that it appears to have been common ground that an appropriate place was the Ferrari factory in Italy. So that's the extent of the reasoning here, because the defendant never actually put forward an alternative place for inspection.
That's one appropriate place. It doesn't say it is the appropriate place.
Indeed, my lady, but there was no other appropriate place.
Why wasn't California an appropriate place? If
That
that's
was-
where it was.
Indeed, that wasn't suggested at the time, so that wasn't pleaded as an appropriate place, and it wasn't a submission made that California would be an appropriate place. The way the case was actually put was that the question of where didn't arise. You can see that at paragraph 108C of the judgment. Which summarises the defendant's position. 108 sub C, my lord.
Thank you.
Sorry, 108 sub B, my lord. The question of place of inspection does not therefore arise because there's no right to inspect. That was the defendant's
But he
case.
was saying that the obligation to tender it was at Canepa's premises in California.
Correct, and I'll come on to look at delivery obligations. But as to the place of inspection, what was one of the reasons that the parties were happy, I suppose, or content with the Ferrari factory in Italy being an appropriate place, was that that's where the expertise was, if you like. And also, as my lady noted, in respect of the contract itself, the car was warranted within the agreement at clause 1.7, and indeed this finds its way into the sub-sale agreement as well, as being at the Ferrari factory, the Classe A department in Modena, which as I understand it is the factory. And so it would make sense, given that that's where the car is, for that to be where the gearbox is also inspected. When discussions were taking place about how to give effect to the shipment provisions and delivery, it was assumed, at least I think between the parties, that it was going to get taken to Italy as a point of inspection. So it was never really suggested that Italy would not be an appropriate place to inspect, because the submission against me on this is just that there was no right to inspect.
So what would happen if it was the wrong gearbox? It's tendered for delivery in California. That's under the contract, they say, and it then has to be shipped to Italy, and it turns out to be the wrong gearbox. Who pays?
Well, in those circumstances, that would be, I think what the judge found in that scenario is that there wouldn't be an obligation to ship so as to facilitate inspection on the seller. So the prices of shipment for the purposes of inspection as compared with delivery, I think, would be borne by the buyer.
Oh, so GF would have had to pay for it to go to Italy to be inspected there.
Yes, I think the judge says that.
Is that so?
That's at paragraph. Yes, it's paragraph 154 of the judgment.
Thank you.
But what was suggested by GFL was that, and you can see this in paragraph 154 of the judgment, the claimant was agreeing to fund the costs to Italy. I think what was actually happening was GFL was saying, take it to London, someone else will take it to Italy, then if it's the right one, it will come back to London. Effectively, I'm not sure if the final bit was precisely said, but I think that was what was suggested in the exchanges. But that's a distinct obligation from the one to ship so as to effect delivery, and the costs of shipment so as to effect delivery. This would be about the costs of shipment to effect inspection.
So has it been delivered then on this hypothesis when it goes to Italy?
Well, what's proposed is what was proposed in the email exchanges with Mr. Carr, treated as repudiatory breach of contract, was for it to go to London, and so that would be essentially delivery, but there would be no acceptance under Section 34 of the Act until such time it had been inspected, which GFL had proposed to do. And then once it had been inspected, then it would be accepted under Section 34 of the Act. And then depending on what had been done, so as to secure its recovery, a fee might have been payable under Clause 7.
So is the critical issue then not so much inspection, but where delivery takes place?
Perhaps, my lord, yes, because that was what it was. It was. If I can, actually, might be just easiest to show you this as the way this was pleaded. If we look at what was treated as a repudiatory breach of contract, which is it in the defence. it's paragraph 18 of the defence, which is at B6, B90. Apologies. Paragraph 19 of the defence. This was the defendant's case as to what constituted a repudiatory breach of contract. And at 19.1, I've already taken my notes to this, but this was the point about the agreement not requiring Mr. Carr to ship the gearbox to Fiskens by way of delivery. Sub 2 is what follows from that, what's said to be a repudiatory breach. 3 is about risks, which really go to the question of whether this was an obligation on Mr. Carr. And then 4 is about whether the agreement entitled GFL to withhold the fee pending verification. So when you drill down as to what was actually alleged to be a repudiatory breach of contract, it's, I didn't have an obligation to ship it to you at your offices in London, and you didn't have a right to verify. So vis-a-vis place, we're talking about delivery, and rights, it's inspection. That takes me then to delivery. And starting with place of delivery rather than costs of delivery, because they're distinct questions. There are 4 competitors for place of delivery. First, there's GFL's address in London. Secondly, there's Mr. Carl's address in London. And those are the 2 I contend for in primary and alternative cases. Thirdly, you've got Canepa's premises in California, which is what my learned friend advances. And then fourthly, I'm not clear to the degree to which this is advanced, but a possibility perhaps of Mr. Carl's home in Florida. So my primary case follows 29.1 of the Sale of Goods Act, i.e. being a matter of interpretation of the contract as to whether there's an obligation to release the goods or send them to the buyer. And going back to clause 7 at the back of the core bundle, I rely on clause 7.6 of the agreement, which says that if the seller recovers the gearbox from Canepa, he will promptly turn it over to the buyer, I should say, without additional compensation. But I'd like to draw a distinction here between the way in which the delivery obligations were set out with regards to the GTO itself.
But before you do, the draftsman of this contract knew the difference between delivery and turnover.
Yes, my lady. You have in this contract there are three different words used with regard to delivery in the legal sense. Whether delivery be effective, and by that I mean whether delivery might be affected by sending something to somebody or releasing it into their possession. Because you've got the 7.6, which is turning over, and then you've got with regards to, well, actually just staying in clause 7, you've got at 7.10, forthwith deliver. And while in my submission there is sense, and I'll come on to this when we look at the fee, but while in my submission there's sense in the fee being payable only when the gearbox is recovered from from a party other than Canepa, there's no real sense in the delivery obligations in respect of the gearbox being different depending on whether it's recovered from Canepa or from another third party. And 7.10 is dealing with the non-Canepa situation, as Milena Friend noted, but that says forthwith deliver. And the Canepa situation is clause 7.6, turnover. And there's no real reason in my submission for those two to be different, because you're ultimately just concerned with the same piece of property that isn't at that stage with Mr. Carr. But compare, importantly, the way the GTO itself is described. So in that we have clause 5.3, which is at B97. So at 5.3, they the reflecting of the passage of title by the delivery to the buyer of the executed bill of sale. So the bill of sale in this case ends up being some sort of document of title as between the parties. Then it says seller will forthwith, after completion, procure the release of the GTO into the control of the buyer. So you've got a clear distinction then between the delivery obligations with regard to the GTO, which are about procuring the release, and I accept that. If you procure the release, you step back. You can take the GTO now.
Doesn't that have something to do with the fact it was subject to a lien?
Well, the lien, I'm not sure, my lord, because the lien was going to be lifted as soon as the monies were paid by GFL to Ferrari Financial Services. So once the monies were paid by GFL to Ferrari Financial Services, there would be no lien over the car. So in that scenario, Mr. Carr would be able to do with it whatever he liked. I can show you that if you wish, because there's a separate agreement in the bundles between GFL, Mr. Carr, and Ferrari Financial Services that sets that out and talks about the release of the lien when the money's paid.
There had to be a release letter in the conditions in paragraph 3.
Yes.
Doesn't that reinforce my lord's point?
Well, that would mean that FFS have released Mr. Carr of his obligations under the lien. But once Mr. Carr has no obligations over the lien, he's effectively got absolute title to the car, and he then is in a position to procure its release to the control of the buyer, which is where you are in clause 5.3. So my point, if you like, is that in clause 5.3, there is a direct obligation with regard to delivery.
But it's not talking about delivery of the car. It's talking about giving an executed bill of sale for good title, isn't it?
So the beginning of...
When you'd think when you look at the title, the title of paragraph 5, that you look eagerly to find out what arrangements were being made for the delivery of the car physically, and one doesn't find it there.
Well, in my submission, my lord, one finds it in the second
papers.
sentence of clause 5.3.
Effectively, what 5.3 is doing, saying this in order that you can correct me, but it's as it were, it's giving the logbook, as it were. What ordinary mortals would be doing when they're exchanging ownership of a car. You'd hand over the papers. That's what this is about, isn't it? Not about what we do with the four wheels.
Well, he's giving, it envisages Mr. Carr giving authority to Ferrari, I suppose.
Yes. To release the car.
To release it.
Yes. But I'm just, when you were illustrating, as my lady put it, that the drafter knew what delivery means. But even when we start rummaging around in other parts of the contract, it doesn't seem that there's very much wattage being shone on the side.
Well, in my submission, my lord, the drafter is deliberately using a different phrase here. I mean, you might say that there'd be no reason why, in a Canepa situation, it shouldn't say that if the gearbox turns up at Canepa, then the buyer will procure the release of the gearbox the seller will procure the release of the gearbox to the buyer. So the same language in 5.3 could have been used in that scenario if that were the contractual intention.
Likewise, delivery could have been used if that were the contractual intention.
Yes, and delivery is certainly used specifically as regards recovery, the securing of custody of the gearbox from a third party other than Canepa, and that's in clause 7.10.
Yes, but a different phrase is used in 7.6.
Yes, my lady. I suppose my submission on that is that when it comes to the gearbox provisions as regard delivery, it would make that there isn't real sense in treating them differently, whereas I can see why there would be sense in treating the car itself differently.
Why does turnover mean send to London as distinct from, say, to the buyer in Mr. Canepa? Well, it belongs to the buyer now. Go and get it from him.
Well, in my submission, my lords, turnover connotes something active. So if we think about a distinction between turning something over and releasing it, if you release something, you step back from it. It's your gearbox now. I don't want anything more to do with it. You've got it. Whereas if you turn it over, you're providing it, and it's an active.
I'm not sure why turnover necessarily means more than saying it's all yours.
Yeah.
Well, my submission, my lord, is simply that it's an active. It has an active element to it because it connotes provision. It's the provision of something as distinct from the stepping back away from it. You're not, when you're turning something over, you're not releasing it, you're providing it.
Right, and all of this, as I understand it, is a stepping stone for saying that Mr. Carl repudiated the contract, and therefore you don't have to pay him anything. Is that the...
No, my lord, that's not my case.
Right, could you just... what's the chain of reasoning here? Because we've already been around the question of where this thing should be delivered to quite a lot. And my understanding so far is that there's one element to it, which is, Mr. Shepherd says, is self-contained, which is really... There's a reckoning to be carried out as between these parties as to who should be responsible for the cost of getting it where. I understand that. But where is this leading to in your analysis of the ultimate issue of the fee?
Well, this ultimately goes to the question, the aspect, the appeal is that there was no right to specific performance. So if GFL was insisting on delivery in a place other than the place of delivery, depending on where that place of delivery was, I'll come on to the point that if he's insisting on delivery at GFL in circumstances where the place of delivery was Mr. Carl's premises in London, then that can't be a repudiatory breach. But if he's saying that delivery needs to take place at GFL and delivery was, say, to take place in Canepa, then you end up into the difficult territory of whether insisting on place of delivery in London would be a repudiatory breach.
Right.
And if it's terminated, then my clients don't have a case on specific performance, because that would be specific performance of a terminated contract. The obligations need to be extant, and so the contract needs to have been affirmed and existing in order for my case on specific performance to work.
But it's in London now. I mean, whether or not it should have been brought here at Mr. Carl's expense, it has been.
Yes.
So now the only real question is who should, on this point, is who should bear that expense, isn't it? I mean, what are we talking about? How much does it cost to send a gearbox from California to London?
I don't know the precise sums, my lord. I understand it's not that much.
Well, I mean, shouldn't the parties know this?
About $10,000.
Right. So here we are in the Court of Appeal arguing about $10,000.
Yes, so I'm sure that that's why we're asking what this is really about. And what significance does California or London, in respect of a gearbox which is now in London, have for the other issues that we have to decide? Does it have any significance on your argument?
The fee issue, no, my lord. But it has it's very significant to the issue of termination.
But why does termination matter now that it's in London?
Well, because my learned friend is trying to set aside the order of the lower court so that there would be no right to specific performance of the contract because it was terminated. And the order of the lower court gives effect to specific performance of the contract. So the gearbox would have to go back, if you like.
The issue is not whether the contract should be specifically performed, because everybody agrees that the gearbox should be united with the car, and it's moving in the right direction, at least at the moment. Whether it's got there or not, we don't know. But the issue is whether the specific performance should be accompanied by a payment.
Yes, that's one of the issues, my lord. But that assumes that the contract hasn't been terminated. The reason I'm sort of driving at this is because if the contract was terminated for repudiatory breach by my clients, then they had no right to specific performance, which is the remedy the appellant is seeking. He's seeking to overturn the order of the lower court. So that he says there's no right to specific performance because the contract was terminated.
Right, so you're defending yourself in order to show us there was no repudiatory breach.
Yes, my lord.
And sooner or later we'll get to the point that therefore you were entitled to delivery of the gearbox for no extra expenditure.
Yes.
Right, and it's I'm remain interested in the for no extra expenditure issue, because to my understanding that is the major issue between the parties, accompanied no doubt by the question of the cost of all of this in the light of the rulings. But
I'm grateful, my lord. Well, in that case, as I'll move on from the place.
well, I'm not saying that is correct, but at the moment I'm not yet understanding what else is there to argue about in relation to this part of the case. So you can either have another go to explain it, or indeed move on.
I'm making the point so as to demonstrate that there couldn't have been a repudiatory breach of contract for insisting upon delivery in London.
Right. So if you were wrong about that, you would say it's not a repudiatory breach.
If the place of delivery is London as a matter of contract on the turnover provision of the contract, on the turnover provision in the clause, then that's not a repudiatory breach to insist upon delivery in London.
Right. It's just a disagreement.
Correct. And alternatively, if the proper place of delivery is Mr. Carl's house in London, in Chester Square, under section 29(2) of the Act, then insisting on delivery at GFL's premises 2 miles away can't be a repudiatory breach.
It's not. It's not.
What if it was California or Florida?
Well, the judge suggested that would be a repudiatory breach of contract. Yes, which is why I'm pushing, if you like, for GFL's premises in London or Mr. Carl's premises in London. GFL's premises in London is my primary case on construction. On 29(2).
And sorry, you say that comes from turnover being an active verb that requires you to actually do something.
Yes, which is what the judge found.
But if we find all it means is release, in the sense of saying there it is.
Well, you could find that it could mean release, or you could find that the agreement is just unclear as to this, in which case you'd be in section 20.
And then you say 29(2)
exactly
leads into your aid.
Exactly, and that then does take us to section 29(2), and under section 29(2), it's either going to be the seller's place of business. There's nothing to suggest that it's been confirmed by my learned friend that Mr. Carl isn't a professional car trader. So you are either at Mr. Carl's residence, or if the contract concerns goods which the knowledge of the parties are at some specific place when the contract is made, then that place. But the contract records at clause 7.2 that the parties don't know where the gearbox is. So in my submission, that component of clause 29(2), which my learned friend said leads to Canepa, can't apply. So the question then becomes, what's Mr. Carl's residence? And given the deference in the Act...
Well, hold on. The contract says that they believe the gearbox is in California and that they've corresponded about it, but they haven't... But Canepa hasn't been able to locate it. But that's where the belief was that it was in California. Everybody thought it was in California.
The contract doesn't record that the buyer thinks it's in California. Clause 7.2 says that the seller believes
Yeah.
the gearbox to be in California. But Section 29(2) of the Act says that if the contract is for the sale of specific goods, which to the knowledge of the parties when the contract is made are in some other place, then that place is the place of delivery. But the parties didn't know that the gearbox was in Canepa. All that you've got in 7.2 is a belief from Mr. Carl that that's where.
Well, they knew it wasn't in
it's
Chester
delivered to.
Square.
My lord?
They knew it wasn't in Chester Square.
They knew it was in Chester Square, correct, my lord. But they didn't know that it was in Canepa. That was just effectively a hunch of Mr. Carl. And therefore, you're in the beginning of Section 29(2), which is the seller's residence once we discount place of business.
Well, they knew it was in some other place.
Yes, my lady.
It doesn't say they have to know what that other place is. Once it's located in that other place, that's the place, isn't it? It's located in California.
Once the person holding it gives the acknowledgement referred to in subsection 4.
Yeah.
Well, the acknowledgement in subsection 4 I don't think was ever given because Mr. Carl wouldn't permit Canepa to release the gearbox to GFL. So it was I think that release was ultimately given by Canepa to Mr. Carl, but it wasn't given to the buyer, I don't think, because there was all this dispute about the $25,000 release money for Canepa.
Now, as we're approaching the break, can I unhelpfully include the possibility that the knowledge of the parties under subsection 2 of section 29 that they're in some other place does possibly involve them knowing where that place is, because it couldn't perhaps realistically be said if there was anywhere in the world and it turned up in Chile, that would be the place of delivery, and the parties had no idea where it was. But there it may be. Shall we have a break at this point and resume at 2 o'clock? I think probably, Mr. Hooper, Mr. Shepherd, we're on track to finish this hearing comfortably today, are we not?
I would say so.
Mr. Hooper? Good. 2 o'clock. Thank you.
All right.